Namaskar, dear students. I guess you people are doing fine. I, Enaniya, Assistant Professor, Government Law College, Ajmer, is yet before you with another video in the series of Right to Information Act. And so far, we have studied Section 8, in which exemption from providing the information was mentioned. So I think you have understood in a good manner till now. And today we'll be continuing from section 9. Section 9 specifically provides a ground for rejection to the Central Public Information Officer and the State Public Information Officer. What happens here in section 9 is when a request for information is received by CPIO or State Public Information Officer, then if such information, if it deals with the copyright of a third person other than the state, then what happens is we will not disclose such information because it infringes the copyright of that person. So that is why we have made it as our priority that we will not violate the copyright of such and such person. Okay, it is specifically mentioned that other than the state. Okay, so state is explicitly excluded from the ambit of section 9. What does it mean is that it is a discretionary power of the state that whether it wants to violate its own copyright or not. Okay, but it is outside the domain of section 9, so it doesn't contain it and doesn't find its mention under the rigors of section 9. Okay, so section 9 just bars the disclosure of such information which infringes the copyrights of a person other than the state. So I think it is very clear to you people. Also, additionally, you must understand that section 9's beginning sentences without prejudice to the provisions of section 8. So, what does it mean? Kindly answer. It means that section 8 will have an overwriting effect. So it is a superior and a far powerful section than section 9. Is it clear to you people? So whenever there arises an ambiguity in the interpretation or wherever there arises a confusion as to which of this section will prevail in case of a clash, then it is section 8. Is it clear to you people? Okay. So far you have understood section 8 and 9. Now let's continue with section 10. Section 10 is based upon the doctrine of severability. So we'll apply here this doctrine, okay, in the wake of different practical situations. Okay, now let's take first this situation which deals with section 8 and 9. And okay, so there might be a case in which an information may be exempt from the disclosure. That is, it will not be disclosed to the public in general. So it might be covered under section 8, either under section 8 or under section 9. So what happens in that case? So here the Central Public Information Officer or the State Public Information Officer might provide that severed piece of information. Okay, the exempted part will not be provided because that is exempted. Okay, and for that section 8 and 9 are there. Okay, so if a reasonably possible piece of information after severance can be disclosed, it will be disclosed. Okay, it is as simple as that. So, whatever can be severed from that kind of information will be disclosed to the public at large. So, this is what we have to do. Okay, because section 8 and 9 are operative, so that information will not be provided, and the grounds are mentioned under section 8 and 9. So therefore, the remaining piece of information after severance, which is okay to be disclosed, will be disclosed, and it will be provided to the applicant. I am sure now you have understood. Okay, now let's take another part of this section 10. The section 10 thereafter provides that the central public information officer or the state public information officer will uh, inform the applicant that the information is severed, and he will be provided information only in the severed part, and why it was severed, the reason for the same will also be provided, that it was exempted from disclosure, that it was not mandatory for the public authorities to provide that information under so and so ground. So that the central public information officer and the state public information officer will not only provide the reasons for the severance, but also they will tell the applicant that only the severed piece of information will be provided to him or her. What happens next? The central public information officer and the state public information officer will also mention the fees details which has to be paid by the applicant undoubtedly, and also the central public information officer and the state public information officer will specify the name and designation of the officer who has taken the decision for severance, such and such severance. Okay. Thereafter, the central public information officer and the state public information officer, this part is my personal favorite, they will also tell the applicant the revision. Okay, that the applicant has the right to get the decision reviewed, and that has to be reviewed before such and such authority. So here the applicant is informed in all the respects. Okay, he is kept in loop in this information, that firstly he will be provided the information that only a small portion of the information sought is provided. Thereafter, the reasons for the same is also mentioned to him. Thereafter, also the fact that he has the power to get the decision reviewed, and that too from which authority, which authority in particular. Okay, so all such informations are provided to the applicant. This is really a very powerful provision, again, which empowers the applicant even more. So today we have understood the section 9 and 10 in a fairly good manner. So do analyze these two provisions in the context of different hypothetical situations, and I do think that you are and I do personally think that you are in a very good position to answer all sorts of questions which may be asked upon these provisions. So and also do not hesitate to ask questions. You can ask questions in the comment box. Okay, and in the end I would thank you people for listening so carefully, and please do subscribe, share, like, and comment upon the videos. Jai Hind.